Good afternoon. This is week 9, Laws 11057, Introduction to Law. And tonight we're dealing with two things: some legal research issues in relation to legislation in particular, and also a hypothetical situation in terms of how you go about applying law in a practical sense. So the research of legal matters for the reading this week was chapters 3 and 5 of Practical Guide to Legal Research. I'm just going to make a few brief comments because I'm sure that you can read the commentary just as well, if not better than I can. But I will say that quite appropriately, generally speaking, you start your legal research with legislation, as we know from our comments in terms of where the law is derived, and also separation of powers. Legislation will override others, so that's the important place to start. By all means, look at the authorised sites, ComLaw for Commonwealth legislation, and also the Queensland Parliamentary Council for Queensland legislation, or if you prefer, the unauthorised reports through Austlii. Nothing at all wrong with Austlii, and in fact that's what I use as a routine commencement point for my research. You hopefully have all looked at, possibly even more than once, the excellent commentary by Kelly Stidiford, our librarian, which is on the front page of Moodle. If you haven't done that, I urge you to do that straight away. She explains the concept of legal research and how you go about undertaking legal research in a very straightforward way. Now, there was the question about assent for legislation both in Queensland and Commonwealth legislation, and you would have seen from that it is important on occasion to look at the Acts Interpretation Act, the Queensland version from 1954 and the Commonwealth version from 1901, both amended of course, and that will give you some guide in relation to when legislation comes into effect through the process of assent. But also the Acts Interpretation Act is something I'd like you to look at generally because it will answer a number of questions that crop up from time to time in terms of your legal research. In terms of what I do, generally speaking, it works like this. Given that at the moment my actual area of practice is quite narrow and almost entirely in criminal law, it doesn't take me long to go to the main sources, the Queensland Criminal Code, the Crimes Act if it's Commonwealth, etc. But most of it's state-based legislation that I'm looking at: the Criminal Code, Police Powers and Responsibilities Act, Drugs Misuse Act, Regulatory Offences Act, Summary Offences Act, things of that nature. So I've got a pretty clear idea where I need to go for the legislation without doing much preliminary research. So for me, it's normally a case of going to the legislation. I'll get there through Austlii, and if I want cases, I'll generally go to the Note Up facility in Austlii. And if you haven't tried that, please do that straight away. It's an excellent facility, and it's very easy to use. Other than that, I use textbooks. As a more formal research facility, I like LexisNexis. And that's not to say that Westlaw isn't any good. It's excellent publication, but in our firm we have LexisNexis. So that's, in simple terms, the way I go about doing legal research. And they're the only comments that I'd wish to make formally about legal research tonight. I know that's quick, but before I move on, and I'm looking to see if there's any questions on the chat facility, or if anyone wishes to raise any questions about legal research, the way they go about doing their legal research, any tips that you have for others that might assist. Any questions or comments? All right, well look, let's move on to the task that I set. And that is the hypothetical situation, as I recall, of you being in a law firm and being asked by a partner to see a client in relation to, as I recall, a consumer issue and a debt or a debt recovery issue. I'm not sure if I'm clever enough to bring up the page. What I said on Moodle was this: have a look at this problem. I want you to think laterally. I want you to broaden your horizons. I want you to go about providing holistic advice to a client in certain circumstances. I want you to brainstorm, and this is examinable. To get you thinking about some issues, please assume that you're now working in a law office. You need to provide you're required to provide instructions, to provide advice to client. who is faced with a legal problem. Let's say a consumer issue or a debt recovery issue, something that partners may give to a first-year lawyer. So something relatively low level. The client wants to know all possible options. What are the advantages, the disadvantages of the options? What are the risks and rewards? What about costs, timings, and alternatives generally? Those sorts of issues. Now, so let's start thinking about those different options. And can I say thank you, Jason, for your excellent contribution through UCrew. If you haven't seen what Jason's come up with, I urge you to do so. Now, Jason, do you want to speak to what you've prepared before we go further?
Yeah, if you like.
Thank you.
I don't know if everyone's seen it or not. It's just last week or the week before you mentioned somebody used flowcharts and you were really impressed with that. And, realistically, it's something that's not that difficult to do once you've done it once. I'll just put it up on the screen now so everyone can see it. I think you can see it. So it's just a basic, meet and greet, then your options you can see down there. It pretty much speaks for itself. Each point can probably have another 10 notes put into it. So I've just tried to keep it really, really simple. I don't know. I think I've covered it, but what does everyone else think?
Great. Yes, thank you very much, Jason. Does anyone wish to make any comments in relation to what Jason has prepared? All very quiet, Jason.
Oh, well.
It must be more comprehensive than we thought. All right. Now, just so we can move on, what do you think I was talking about when I talked about brainstorming and providing holistic advice? What do you think that means?
Sorry, is that question directed at me?
Anyone, but it could be you, Jason. Now that you're there.
Well, I think it's just you're starting to try to get us to think outside the square a little bit, probably more like a business situation rather than a student, what's going to happen in the real world, so to speak. That's my thoughts.
Okay, and I guess there are a few things to get you thinking about this. Firstly, if you were providing advice as a legal practitioner, you need to understand the extent to which you are supposed to provide that advice. For example, if you were providing advice to a client who faced a consumer complaint issue, let's say, a dishwasher that's faulty, and they came to you for legal advice. Now, is it appropriate for you to say to the client, yes, you have a case and we should institute proceedings in the magistrate's court claiming damages, and we'll do that immediately? Is that appropriate advice? Is that a good option?
I would probably suggest that you'd advise the client about the costs and the length of time here, and also the damage to their business if they're going to take on a customer in court. In the long term, it'll probably be far better for their business that they come to some sort of agreement and leave with a happy customer, even if it does cost them a little bit. Even giving up a dishwasher would cost them less than taking the whole thing to court.
Absolutely. No, thank you very much, Anne. And I think that's right. I think the cost and the time associated with it are all very important. And what you've identified is really important, and that is that we need to think laterally. And there are a few comments coming in now on chat. In the initial advice, we need to think laterally. Probably not appropriate to think about going to court immediately if the dollar amounts are low. To pick up on a point that you made, Annie, holistic means inclusive, so consider all needs and specific situations. Nicole suggests ADR, totally agree. Try to negotiate, says Tim. Kirthy says, what about mediation? So now we're starting to get some different options coming through. But the initial point is this: what is the role of a lawyer in those circumstances? What is the role of the person giving legal advice? Is it simply to talk about black letter law? You have a case, let's go to court. Or are you required to think about dispute resolution, as Tawanda has suggested, or other options. Now, I think your role is to think laterally, holistically, and provide a whole range of options to the client, and not just assume that because you're a lawyer and you do litigation work, that you must therefore restrict anything that you do or say to the litigation context. Now, does anyone disagree with what I've just said? So Gordon says, to the best effect for your client. Okay, so I think what you need to do is consider what's in the best interest of the client, and that may not be, as Anne pointed out, going straight to court. It may be that we need to consider those other options in a more holistic sense. So what options have we generated so far? Number one, try to negotiate with the other party. Number two, go to court. Number three, mediation. Now let's think of it in terms of, say, a person who's owed some money. What other options might there be? Or perhaps a person who is a consumer who has a problem with a faulty car, let's say. What options are there? Debt recovery, says Kirthi, yes. That's when we talk about debt recovery, that's probably more through a court or tribunal. Anne says yes, through a tribunal. Gordon, a letter on letterhead from a solicitor may get things moving, depending on the state. A letter of demand, ombudsman. So we've got another option coming through. So the ombudsman would be a complaint to authorities. Can we think of any other options? Is it appropriate that we talk about these options to the client? Meet with the owner of the company, so some direct approach. Start by talking to the other side. Good idea. So what we're trying to achieve is going to be dependent to some degree on the extent of the claim. If it's a low-level claim and you're dealing with a client without much funds, without a great deal of funds, you might want to look at these alternate options even more carefully than otherwise would be the case. So Gordon says, yes, present all options, as does Nicole says QCAT. Tony says, what other options are there? Talk about those options. Tim, lodge a lien on property. Now there's a lateral thought. So take some form of direct security in relation to something owned by the other party. Get from the client what they want from the claim. All right, so there are a whole range of different options that might be available, and I'm working on the assumption that it's appropriate to consider those other options, and in fact it's necessary to consider those other options in that first interview with the client. Lodge a caveat. Still need to go to court first, says Anne. Yes. For those of you who haven't heard the terms lien and caveat, I'll just describe them briefly. It's not examinable as such, but a lien is an interest that you claim where you might retain some property as security for a debt that's owed. So if you have a car that's now, Leslie, I'll just get you to mute your microphone. That's right. I've got it. If you have a car, if you're a car repairer and you've done the work and the person hasn't paid the car, then you might claim a lien, which means that you say, essentially, I'm not giving you the car back until you've paid the money. Lawyers will retain a lien on the file in that situation. Nicole says, is that classed as conversion? Now, here's an interesting thing. For the first time, we have a comment in relation to criminal law, and that may apply in dealing with a consumer issue or a debt issue, perhaps. It may be that criminal law has to be considered as part of the holistic advice. So if, for example, a client came to you and said, I'm chasing some money, you ascertain that the reason they're chasing the money is that that money was stolen from your client, then maybe you think about going to the police as another option. So I was talking about liens. I'd mentioned what a lien is. It's sort of a security interest to retain property until such time as you're paid. A caveat's a little different. A caveat is typically where we lodge a document over the title of a property owned by someone, and in that caveat you're essentially claiming an interest in the property. So you need to do that very carefully. So Nick says fraud, criminal code, yes, that's all recently. You don't have to lodge a caveat to go to court, but depending on the type of caveat, it provides you with an opportunity to go to court within a period of time, 3 months, in order to support that. How lawyers get paid before a bank, I'm not sure about that one, but yes, perhaps so. And you'll try and take a security interest. Has anyone heard of the personal property securities register? So maybe you talk to the client about that. If they're owed money, maybe they want to come to a deal, try to get some security over the interest of the other party by claiming some interest over or lodging a security interest pursuant to the PPRA regime. All right. Well, there's one fairly obvious one that hasn't been mentioned, I would think. Now, let's assume that you're acting for, I don't know, let's say a 70-year-old woman who is owed some money from, let's say, her son. She lent the money to her son, $10,000. He hasn't paid it, and she comes to you for advice. What other things do you think you might say? What other ideas? Libby's got it. Consider taking no action. Is it appropriate for a lawyer to say that? You've got a good case, but in the circumstances, you need to weigh up the emotional cost, the financial cost, your health, other issues come into play. So maybe you should consider not taking action. You might say, I'm not suggesting that to you, but I'm putting that to you as an option. And I think that's entirely appropriate. Jason has raised the legal issue. Is that a social agreement? Is there intent for legal relations? Yes, and that would be entirely relevant if you went to court, because you'd need to establish that there were those issues. Melissa, relationship is more important. So I think it's entirely appropriate to raise that sort of issue with a client. Maybe mention in the will that the debt would be reduced from his benefit. So some lateral thinking there. So that's so Anne's come up with a left field approach to it, saying, well, look, let's not even take on this problem. Let's deal with it in a different way completely. Is that appropriate for a lawyer to give that sort of advice? I think it is. I think it's appropriate. Again, our role is to look after the client and come up with the best possible solution. All right, so let's take a different scenario. We're now acting for a client who is leasing a commercial property from a friend, and they're having a dispute over the rental, what that rental should be. What are some of the options? Well, maybe you suggest to the client, look, you've known each other for a long time. Why don't you just sit down with that client and be honest and upfront, and maybe try and sort things out over a cup of tea or a beer. So in that instance, anything is appropriate if it's legal, isn't it, John? Yes, I think it is. I think it's, provided you're giving legal options, I think it's appropriate. Tim, very good. Now, this is something that hasn't been discussed so far, and that is bring in a third party to assist in the adjudication. So Tim says, appoint an independent valuer. So let's not take this problem on directly. Let's not try and negotiate it. Let's think of a different way to approach it, a left field approach. If you can't agree to a lease, there wouldn't be a contract, so there'd be no recourse. Yes, so there'd be the issue of the threshold issue. Is there in fact any agreement at all? Is it an option to simply walk away, do nothing about it, go and rent something else? If you were to give that advice, you need to be careful that the client's aware that the other side may have a different view and pursue you. All right, so some lateral ideas coming up now. Mediation was mentioned early on. Now, given that I take ADR, it's probably natural that I'd be thinking about mediation. But tell me about the different types of mediation. Is every mediation the same, or are there different types of mediation? Anyone been involved in mediation before? Yes. So I can give a plug for the ADR course if you're thinking of electives down the track. Yes, yes. All right, so mediation. There's a very basic but very high quality mediation service which is conducted through the alternate dispute resolution centres, which are generally annexed with courthouses, and they provide a very low cost form of mediation. Under that model, which is a pure mediation model, 2 mediators are appointed, and it's very much non-intrusive in the sense that the mediators will not come up with ideas or intervention. We can contrast that perhaps a neighbourhood approach to mediation which is conducted in a more formal setting, perhaps with a lawyer as the mediator typically, maybe a barrister or a QC, very expensive, and a formal mediation where you have, let's say, a QC as the mediator and both parties are represented by lawyers. So it's one thing to say mediation, but I think it's another thing to talk about the type of mediation. Now, some people have mentioned going to court, maybe going to a tribunal. I think it's appropriate that you talk about the option of doing this, aiming to have the mediation conducted, but within the confines of the court or the tribunal setting. In other words, let's initiate the proceedings, let's go to the tribunal, let's go to the court, but what we're really wanting to do is seek an order from the court or the tribunal to have this matter referred to court annexed or tribunal annexed mediation. So that's a third type of mediation, and all of these are relevant options that you might want to consider. And one advantage of doing that is you might say, well, look, I think we need to give the other side a bit of a prod to show that we're serious about it. We still want to resolve this through alternate dispute resolution, but let's initiate the proceedings, get it into the tribunal, and then we'll go to the mediation session, because if the other side isn't going to be cooperative at the mediation, they'll know that they'll have this big stick hanging over their head that they then have to face the tribunal or court proceedings because we've already started them. So these are different options. Only in family law and litigation are they both quite different. Yes, there's different mediation sessions in different jurisdictions. In family law, we have the dispute resolution practitioner regime, and the dispute resolution procedures are generally conducted through the court process. Or perhaps even I could correct that and say that in a family law context, you need to undertake those mediation processes before you can actually initiate proceedings in court for parenting issues, where someone decides there is a facilitator. So Tim's come up with another idea. Let's not go to mediation. Let's up the ante, and without necessarily going to court or tribunal proceedings, let's go to something that looks a little like court or tribunal, maybe arbitration or facilitation. It's another form of alternate dispute resolution, but it's down a notch from court proceedings. All right, so we've talked about those issues. Someone did say something about, and I think it might have been Robin, going to the Ombudsman, and I made the comment, okay, we're making a complaint. Now, let's say you've got a problem with a car as a consumer. Where do you make your complaint? Do you advise the client to make a complaint? I think you should probably consider it as an option for the client. So where do you make your complaint? Consumer Affairs, yes, Kirthi, agree with that. Department of Fair Trading, more specific, Jason, yes. That's at the state level. If it's at the federal level, that would be the ACCC. Fair Work Australia, says Tony. Yes, so depending on the nature of the dispute, someone comes in and says, I've got a problem with my employment, then you go to Fair Work Australia. Melissa says the appropriate industry ombudsman. Yes, more targeted. So if your client comes in and says, look, I've got a problem, my bank has been overcharging me, then maybe what you do is go to the banking ombudsman. Or if your client comes in and says, I've got a problem with a decision that's being made at a government level, go to the government ombudsman. Human Rights Commission, says Robin. Yes. ASIC, says Sarah. So these are all good suggestions. And these are all tailored. These are all complaints, but they're all tailored. We've still got someone else that we can go to and complain. Nobody's raised this one yet. Mobile phone, go to the telecommunications ombudsman. Yes, Gordon, I agree with that. We also have the insurance ombudsman service. We have energy consumer protection office, which deals with energy issues. Anthony's got the one I was looking for. Your local member. Don't forget it. It's an option. You say to your client, look, you've got a problem with someone making noise and the council's not doing anything. I wouldn't go that far, Robin. He's very good, but not. Sorry, Tony. I would say. So yeah, go to the local member and make a complaint. See if you can generate some activity. All right. What if that doesn't work? Nobody's mentioned the guru. Well, we've mentioned guru in the context of Tony, but where is the ultimate form of complaint that you can make to try and get something moving? I'm not suggesting you do it all the time, but if you really want some action, that's it. Kirthi and Tim, dead heat, and Tony, TV media. I'll pass on that one, Jason. And Tawanda's raised the issue of the police. So TV and media, is that a valid, appropriate thing to do? I think it is in some circumstances. Tawanda says, when do you go to the police? Well, I think if there's some criminality involved, then that should be part of the initial intake. So I made comment in relation to someone says, look, I'm here because I want to get my car back. Someone stole it. I want you to issue proceedings against them. You say go to the police. You need to be very careful if you do that, though, that you don't cause your client to commit a criminal offence inadvertently. It's very easy for a client to say to the other side, unless you do this, unless you pay me that, I will be going to the police. If you do that, that in itself is potentially, very likely, a criminal offence. Right, so Gordon says it might be catching the tiger by the tail to go to the media. I agree. If you go to the media, you need to be very careful. And I'm not suggesting you do it all the time, but it can be a useful way of resolving things. How many times have you seen a current affair or one of those shows, and I don't watch them very often, but where they'll run the story and then they'll follow up a week or two later and say, well, following up on that story, yes, the car manufacturer has agreed to provide Joe Bloggs or Mary Bloggs with a new car as a result of the story. So maybe it's a tactic to consider. All right, so we've talked about the police, we've talked about making complaint, we've talked about tribunals, alternative dispute resolution centres, we've talked about government agencies, anti-discrimination is another one, superannuation complaints tribunal, welfare rights. Now, what if it's an issue, you've got a client who comes to you and says something like, and maybe the client comes to you with, let's say, a son and says, look, my father is now elderly and he's really very forgetful and I'm concerned he has dementia. And his friend, who's only known for a couple of weeks, has somehow borrowed a very substantial amount of money from my father, and I'm really concerned that Dad didn't know what he was doing, and I'm just here to help. I mean, what sort of issues come to your mind in that scenario? Thinking outside the box now. Any options? We've got an elderly man who may well have been taken advantage of. Guardianship application, yes, Tim. Power of attorney, yes, Libby. These are very good options. Family doctor, yep. And these all may be tying together. So maybe what we need to do is say to the client, look, let's firstly consider your capacity. And when I mean capacity, there's a very particular definition of this in the Guardianship and Administration Act, and that is a person is deemed to have capacity if they can understand the nature and effect of decisions they need to consider, if they can communicate their wishes meaningfully, and they can do so without being under duress. Capacity is at different levels. So a person might have perfect capacity to make simple decisions, but be completely incapable of making complex decisions. So keep that in mind as well. So what you might say is, look, let's involve the family doctor, let's get a health professional report, let's ascertain whether you do have capacity, and as Tim said, maybe we do go to the guardianship board, that would be QCAT now, in relation to a guardianship order or an administration order. The question is, elder abuse, very good. Go to the Seniors Legal Service and see if they'll assist free of charge. There's certainly a very active Seniors Legal Service in Hervey Bay, so they might be able to help as well. Approach the rest of the family, get them involved, and then Melissa says, how do we actually go about getting the money back? All right, well, again, thinking laterally, one way that we might do it is if there's an application made for the appointment of a guardian and or an administrator, then that guardian or that administrator will then chase the money back. No, Nicole, we're not going there. So that's another way of doing it. So let's appoint a substitute decision maker to do that work for us. And that's the appointment of the guardian or administrator through an application in QCAT for guardianship, maybe involving the Seniors Legal and Support Service. All right, let's come back to this issue of a car. Someone says to you, this car it's an absolute lemon. I'm not getting anywhere with the dealership. What else can I do? There's another option that nobody's considered yet. All right, so I'll make it a bit more obvious. The person comes to you and says, I tripped over while I was at Coles and I think I need to claim some damages. Libby, insurance, that's it. So let's see if there's a third party that has some deep pockets that we can make the claim through. So let's not worry about suing the person who you dealt with. Let's see if we can deal through the insurance company or through some other agency. So if somebody comes to you as a victim of crime and says, look, I would like some compensation, at least to cover my physio costs, etc., then maybe we do a victim of crime application. We forget about the person who committed the crime and we go to the government agency and claim through victims of compensation. So what we're doing there is we're thinking laterally, is there a third party, is there an organisation that can help us in these circumstances? And you probably think about all of these things, to be honest, before you go to court or tribunal. So we started the discussion as if someone comes to you and says, I have a legal claim. You think, well, I'm a lawyer now, so I'll pursue that legal claim. We go to the court, we go to the tribunal, and away we go. But I think the real answer is that we have to think about all these other options and at least put those to the client for consideration, and the client makes the choice. We've mentioned a few shortcut legal remedies which involve taking direct action and not necessarily going through court or tribunal. I think it was Tim mentioned caveat. There was another one. Someone else mentioned a lien. If we really want to be very tough about things, if we're pursuing a company, we can serve what's called a statutory demand, which is essentially a claim saying, pay this, and if you don't, you will be liquidated. And you can do that without even going to court and getting an order. Now, I'm not asking you to look into statutory demands because it's something that you'll deal with in corporations law, but I will mention it as an option, but I'll say proceed with extreme caution before you issue a statutory demand. They can be pretty tough. Proceed with great caution before you lodge a caveat as well in a real estate dispute. So I'm mentioning these names. I don't expect you to go off and do lots of research on them, but just be aware that there are, if you like, legal remedies which are direct, which don't involve going to court. Caveats, statutory demands, things of that nature. Okay, Gordon says, what if the complaint is statutory as well as compensatory, like workman's compensation? Okay, another one. Yes, if your client walks into you and says, I'm owed money, and you ascertain that your client is in fact a subcontractor, then there is the remedy of claiming a subcontractor's charge as well. Libby, yes, this one hasn't been mentioned. Bring in a third-party advocate to help you, like a union. We've talked about maybe getting a guardian or administrator to help, but more direct, get a union if it's an employment dispute. I hadn't thought about that one. Thank you. All right. Now, if we're talking to the client about going to a court or tribunal, we need to talk to the client about what? We need to talk about the prospects of success. Someone mentioned that in the context of a contract between family members. Will we have a problem in relation to this being just a social agreement? Okay, costs. We need to talk about costs, absolutely. Health and stress, yes, and the time frame. These are all really important aspects. So we need to talk about whether they've got a claim, the cost associated with the claim, time frames, stress, etc. Tell me about costs. If you proceed in a court action, what costs do you incur or do you potentially incur as a result? Any thoughts? Other party costs. Yes, Tim. None or all? There is that real risk. If you issue proceedings in court, then if you lose, or if you come second, or if you get the silver medal, as we say, you may suffer an order for costs, which means that you're paying your own legal costs and you're paying probably not all, but a fair proportion of the other side's legal costs as well. That needs to be considered. And it's not just the lawyers, it's the other things such as application fees, barristers, expert witnesses, those sorts of fees, filing costs, they're all relevant to the situation. So there's a real risk there as well. Okay. What about timing? Do we need to talk to the client about limitation periods? So what if the client walks out and says, well, I'll think about all that, thank you very much. The last thing you should be saying to the client is, yes, but remember, of course, that if you want to pursue your remedies for breach of contract or breach of tort, you'll deal with torts and contracts later in the course. Statute of limitations. Thank you very much, Nicole. You've got to mention the statute of limitations, and you've got to say, if you don't issue your proceedings within the prescribed period of time, then you run the very real risk of losing your entitlement to do so forever. And guess what? If you don't give them that advice, who do they sue? If they run out of time, they just turn around and sue you. So you should confirm all these things in writing. So I guess what we've identified today is this, that if someone comes to you for some simple what seems to be simple advice, look, my son borrowed $10,000 and he hasn't given it back. What do you think I should do about it? I guess the temptation is to say, well, let's initiate court or tribunal proceedings, but there's a whole lot more to it than that. And of course, the difficulty that you'll probably face even now as first-year students is that people know that you're learning about the law, and I'll bet they're seeking legal advice already. So you go to afternoon drinks, having a cup of tea, someone will come up and say, oh, look, I'm sorry to worry about this, but listen, here's the situation. I've got this problem, and they'll seek your advice. Everything is on the record. Thanks, Tony. everything's on the record, so you can find yourself being potentially held to be liable. I think it'd be pretty tough as a law student, but certainly as lawyers, we get it all the time. As soon as we walk outside, people are after advice. And our indemnity insurers would say to us that what we should do, even if we didn't charge, even if we didn't open a file, is that we should warn them of all these issues in writing at the first available opportunity. It's exhausting, but it's necessary. Jurisdiction. Oh, yes. Now, Robin's raised an issue we haven't talked about. Thank you for reminding me. Jurisdiction. Sometimes we go to the federal court. Sometimes we go to the state court. Different impacts require different results. I totally agree with that, and it's a matter of doing the appropriate research. Okay. Melissa's finding she's getting questions already as a law student. Okay. Look, I hope I haven't hit you with too much, but the purpose of the exercise tonight is to remind yourself that law is very much holistic, and that even though you're doing introduction to law, you've got to be mindful that there are different aspects of law. There's civil litigation, criminal law, torts law, contract law, and all these things may come into play in any situation. And it's not just a matter of following the straight line. You need to consider those alternatives to litigation that might be relevant. All right, well, I might wrap up the recording now, unless there's any final questions or anyone wants to ask a question on camera. All right, well, all the best. I'll stop the recording now. Thank you.